Testing 1 2 3. Testing 1 2 3. This is a test of the Seventh Circuit Court of Appeals. Testing 1 2 3.
Good morning, everyone. We have 6 cases on today's oral argument calendar, and we'll begin with appeals number 232630 and 232727, Boone versus the Illinois Department of Corrections. Ms. Hager, nice to see you. Good morning.
May it please the court, my name is Bethany Hager. I'm here today on behalf of the plaintiffs, appellants, and cross-appellees in the Boone case that's before you. Your Honor, since this case has been before this court previously on a limited issue, remanded back to the district court on that limited issue and disposed on that issue, that's where I'd like to begin. And that issue is plaintiff's position that Public Act 102-667 in November 2021 did in fact amend the Healthcare Right of Conscience Act in Illinois, and on its face, that amendment violates the right of Illinois workers, specifically the state workers and others similarly situated in this case, to be free from religious discrimination in the workplace.
Ms. Hager, how do you get around the Illinois Appellate Court's opinion in Glass?
Thank you.
Which you did not address in your briefing.
Okay, I'll address that now.
Please.
I do think there's some problems with the interpretation of the appellate court in that case. For one thing, the issue in deciding whether this was an amendment or merely clarification, you have to look at, was there a need to clarify the law in the first place? And when the appellate court in Glass has this discussion of the need to clarify the term discrimination, that's a brand new idea that had never been floated before by anybody. Nobody thought that there was a need to clarify the term discrimination in Healthcare Right of Conscience Act. And so that's a rather tenuous basis for the appellate court to then say, well, we need to clarify this word that's not part of any of the discussion in passing this
So
public
we
act.
have to determine whether or not there's any persuasive reason the Illinois Supreme Court would not follow the Glass opinion. So if you could please just frame your argument to us in terms of that, because that's the determination we have to make.
Sure. So the Supreme Court declined to take up our appeal in the Glass case.
Correct.
And I think it's difficult to then suss out any reasoning or logical basis based on their failure to take
Well,
up
that
the
certainly
case.
doesn't help you.
I agree. It leaves in place the decision and the state of the law as the appellate court left it, but it doesn't affirm it. It doesn't necessarily say that the Supreme Court agrees with that reasoning. It just says that at that moment the Supreme Court is not going to take up that issue or that case.
But
And so-
doesn't that suggest to us that there isn't a persuasive reason that they wouldn't follow it? That's a double negative, but
I think I understand what you're saying. And I don't think it has to say that to you. Because when a federal court is analyzing the statute and the amendment to the statute, in light of, does the statute and the amendment comport with federal requirements to keep workplaces free of religious discrimination, that's a larger analysis for this court and for federal
But it's
courts
still an
than simply
underlying
that
Illinois
interpretation.
legal issue. Well, the cause of action here is federal. The underlying question of the impact of the public law on the underlying statute is an Illinois legal issue.
So I do think you have to take it into account, but I don't think it's persuasive on this court, especially when the reasoning that is in that opinion is, as I said, tenuous.
Has any court, to your knowledge, disagreed with Glass? since
There's
it
not
came
been many cases filed or any cases filed since that or that have reached to the appellate level. So it is sitting out there as, the current most
Ms. Hager,
recent.
assume for just purposes of our dialogue here in the courtroom, assume that Public Law 102-667 did not change Illinois law. It had no effect on Illinois law. That's what the statute says. That's how Glass interpreted it. That's what our prior opinion said. Okay. If you accept that premise, just for discussion purposes, do your clients have standing?
I think they do. And first of all, it's in our
I know
briefs.
that's not
We
your
do.
position.
That's not our position. But even assuming it's
How
not a
could you
change
have
to the
how can you
law.
have Article 3 standing? How could a statute that has no effect on existing rights and obligations inflict injury, cause injury?
Okay, so let's presume that this new Amendment Section 13.5, Public Act 102.6 and 7, made no change to the Healthcare Right of Conscience Act.
Right.
Then you're faced with an issue where the act, supposedly as it was written, says you can have your religious freedom in the workplace except for this one disease. When it comes around, you
Right,
don't
so
get your religious
I
freedom
understand
anymore.
that position from your brief, but that seems to me to be a challenge not to 102.667, but rather to the Conscience Act of Illinois. In other words, if you accept the premise for discussion purposes, it seems to me that the substance of your client's position is one that is challenging the Conscience Act.
Essentially, it would fall back to that. The Conscience Act
But
is
that's not what's before us, though, is litigation challenging in isolation, at least as I've interpreted, or I've understood the litigation, 102.667. In other words, your clients would be free to lodge a challenge, constitutional challenge, or other challenge to the Illinois Conscience Act in light of the vaccine and testing mandates. They could do that, but that just doesn't seem to be this litigation.
that's what this litigation has required by process, required them to fall back on. But you're right, initially,
But
plaintiff's
which
position
cause of action
remains-
did you bring that challenges the Conscience Act?
No, it's not there initially because plaintiff's position is that the Public Act amends it, and by amending it, that is the violation of their right to be free from religious freedom in the
Yeah,
workplace.
so when the litigation gets isolated to 102.667, that's where I think it gets very difficult for your clients, because that statute is akin to like the federal analog of the sense of the Congress or something like that, where it just, by its terms, it doesn't affect rights and obligations.
And I think procedurally, plaintiffs would perhaps seek and want to go back and amend to have that initial challenge in an amended complaint, but that's just procedurally not how the litigation has moved forward.
Under what theory could you go back and amend to add challenge to different laws?
If the court tells my clients that that's the only way that they can move forward,
No, wait a
then
minute.
that's the path
That's the
forward.
way you pled the complaint. You challenged a particular law.
Mm-hmm.
If you don't have standing to challenge that law, are you asking for a do-over? I mean, I'm not sure. What are you asking us to do? I mean, if the law is clarifying and not amending the Conscience Act, I don't see how you can claim injury from the law, the public law 102.667.
Frankly, I
And
don't.
then, go ahead. Are you just asking us to allow you a do-over in district? I mean, what are you asking us for?
I don't believe plaintiffs need a do-over. I
Right, but
think
let's say we do. Let's say
Okay.
we think that. Okay.
Then I'll have to assess that in the moment. But as it stands now, I believe it's highly illogical to say that Public Act 102.667 merely clarified healthcare right of conscience.
Right, so
Act.
that's kind of gets at Judge St. Eve's question. So and you're clear on that. It's not, we get that. What you're saying is that the Illinois Appellate Court in Glass is just simply mistaken.
I believe they were.
Right, okay. But the they're the final say on state law that, the Illinois courts are. So unless there's some indication that the Illinois Supreme Court would agree that the Glass decision is wrongly decided, we got to be pretty careful about not following that.
I agree you have to be careful, but I think you can thread the needle. And I think the decision of the Illinois Supreme Court not to take up the case does not prove from the negative that the appellate court was correct in that reasoning and in that conclusion.
Yeah, okay, fair enough.
Okay.
Do you agree, there's a couple of just little items that are at the fringes of this that I want to make sure of. You're not challenging in this appeal, are you, the district court's November 2022 dismissal of the Title VII and Cosmetic Act claims?
So not the dismissal of the Cosmetic Act claim. I do believe that the state's appeal of that decision, which I could not address until our cross brief, did bring back the Title VII claim issue, and so we addressed that in the reply brief. But
But you're not appealing it separately.
Not separately, right?
Okay, and as it stands, it's dismissed.
That's correct.
Okay. And do you agree that the district court's judgment, it had some I think just clerical errors about it, as the red brief points out? Do you agree that those errors should be modified or corrected?
I don't dispute the clerical errors should be corrected. That's
okay.
right. Okay, if there's no other,
Do you, just one other quick question, do you concede that you did not obtain a right to sue letter from the EEOC?
we filed the claim in court while their EEOC claims were pending, and because of the nature of the claims, it's our position they didn't have to wait for those right to sue letters.
But
to
do you
come through.
agree, as of today, you have not received a right to sue letter from the EEOC?
For the 5 named plaintiffs?
Yes.
I would have to go back and check if they've each received their letters, but it's been 3 or 4 years. Circumstances, even with their individual employment, changed, so I can't answer for you right now.
I didn't
if they've
see
received.
anything in the record anywhere where right to sue letters were filed with the court,
Okay,
which suggests to me you didn't receive them.
then they possibly didn't come through the file or weren't considered necessary to be
Or that you
placed into the
received
record.
them. You're resisting
I don't
answering
know.
that question.
I can't answer
Okay.
either way, so I'll agree with you that they're not in the record. I'll reserve the balance of my time for rebuttal unless there's other questions.
Yeah, no, that's fine. Let's hear from the Department of Corrections and we'll come back to you. Good morning.
Good morning. May it please the Court. Assistant Attorney General Lee Jonig for the appellees, cross appellants. Unless the Court prefers otherwise, I'd like to start with counts 3 through 5, which are the challenge to the Right of Conscience Act amendment, and first the plaintiff standing to bring those claims, and then the merits, and then go on to the first 2 counts of the complaint, the Title VII and Cosmetic Act claims. So, with respect to the plaintiff standing to challenge the amendment to the Right of Conscience Act, Section 13.5, as this court held in the first appeal, the plaintiffs lack standing to bring those claims if Section 13.5 is a declaration of existing law, and the Illinois Appellate Court has said that it is. This court should only depart from that interpretation if there is a convincing reason to do so, and here there is not. All of the data suggests that this court should follow Glass. First, the Illinois Supreme Court denied review. The state legislature has said that it's a declaration of existing law. Glass is consistent with Illinois law about how to decide if an amendment is a declaration or if it's a substantive change, as we explain in our brief. And even if there are multiple possible interpretations of a statute, this court should generally follow the narrower one with respect to state law, and that's what Glass's interpretation is.
Ms. Jonig, let's assume that we agree with you on that. Okay? Do we have to do anything further with respect to 102, 667, and all of these alternative arguments that I understand why you advance them in your brief, but do we have to entertain any of them?
No.
We can just stop. If there's no Article 3 subject matter jurisdiction, I don't think we can address the merits. That's
Correct.
the Steel Company decision from the Supreme Court.
That's correct.
There's no authority to do that.
That's correct. We advanced arguments about why those counts 3 through 5 didn't state a claim in the event that the court did determine that there was standing.
Yeah.
But our position has always been that there is not. Glass states what Section 13.5 means, and as this court has held, accepting that conclusion from Glass means that the plaintiffs lack standing, and this court can end the analysis there. Plaintiffs' arguments for departing from Glass, as I understood them today, are that Glass has, I think, some problems and is tenuous, but that does not meet the high bar to depart from a state intermediate appellate court's interpretation of its own law. And so, for that reason...
The statute, by its terms, says it's not changing Illinois law.
Correct.
Right?
That-
So Glass would have had to hold that the legislature could not possibly have meant what it said. And that's not what Glass did. Glass construed that public act like we construed the public act, taking the legislature at its word. It's not a change of law.
Correct.
It's more sense of the legislature or something.
Yes, and
It's an
that's
odd-
just
yeah.
one of the many indicia here that the Illinois Supreme Court would not depart from Glass. And again, these just having potentially some problems with its reasoning is not, as is the only argument that the plaintiffs advance, is not a reason to depart from that decision.
Can we read into the fact that the Illinois Supreme Court did not take it up?
I think it's certainly not a dispositive holding,
Right.
and we don't suggest that. But what this court is doing in this inquiry is looking at kind of all the data that's out there and determining if there's a persuasive reason that the Illinois Supreme Court would rule otherwise. And the fact that the court denied review is, certainly sort of weighs more to our side, even if it's not kind of dispositive on that question. So unless the court has any further questions on the standing
Yeah,
issue.
can you shift to the Title VII and cosmetic? I just don't, I don't see them in front of us on appeal. Maybe I'm mistaken about that. They were dismissed, and Ms. Hager acknowledges she hasn't appealed the dismissal of them.
Correct, Your Honor. As we noted in our brief, the plaintiffs forfeited any challenge to that dismissal by not raising it in their opening brief. I do want to address this contention that, by cross-appealing, we kind of opened the door to it.
Could you explain why you cross-appealed? Because you won on those two claims below.
So our position is that the Title VII claim was properly dismissed for lack of exhaustion, which is a dismissal without prejudice. If the court were to disagree with that or simply not reach the issue, it could affirm on the alternative ground that it fails to state a claim, which is what we advanced, and that would, I think, be a dismissal.
But it's not up on appeal. Plaintiff hasn't appealed the Title VII, so again, you won. I don't know how you can now bring up an alternative ground for us to address it on. It will stand as dismissed for failure to exhaust.
Sure.
As the district court ruled.
Because the plaintiffs
Because
essentially...
they haven't appealed it.
Right. And when we filed our notice of cross-appeal, I don't think we would have known that the plaintiffs would sort of forfeit a challenge to that. Our position was when they appealed from the final judgment, any previous order from the district court would have been fair game, so they could have appealed the Title VII claim. But,
And you may have been, you don't have to answer this, but you may have been thinking that if you want to modify the judgment, you need to cross-appeal.
Yes, that is our position. So if the court wants to reach the merits of that, it could affirm on that alternative ground.
Even though you won, you 8 days a week, you would like a with prejudice dismissal over a without prejudice dismissal.
We wanted to provide the court with that option if it wishes to reach that issue. Our position, especially in light of what we now see to be the forfeiture, the court can certainly affirm on the basis that the district court dismissed the claim or simply on the plaintiff's forfeiture of that claim in their opening
I don't
brief.
know why we'd have to do anything, though, because it's technically really not before us. You said affirm on the Title VII. If plaintiffs haven't properly appealed that and you won, I'm not sure how you can appeal it and give us the opportunity to affirm it.
If the court believes that the claim is not before it, then that, we certainly accept that position as well.
What about the Cosmetic Act?
So the plaintiffs, again, did not appeal that
Correct.
claim. They haven't advanced, even advanced any argument here.
I would agree with that, but you appealed it, and again, you won below.
I don't believe we advanced the
You did, okay.
Cosmetic Act claim on cross-appeal.
Okay.
Unless the court has any further
I
questions.
just have one more quick question for you. You have asked the court to correct some clerical errors. Do you agree that we need to give the district court leave to amend to correct it, that that's not something we can do on our own? So there were clerical errors in the judgment. Is that something we can on our own correct, or do we need to send it back for the limited purpose or give the district court leave and direct them to clarify it?
I believe the court can do it on its own, but I'm not certain of that, Your Honor. I think either way that issue is not disputed, so insofar as it needs to be a limited remand, the district court could certainly correct that as well. Unless the court has any further questions, we ask the court to affirm the dismissal of this action.
Thank you, Ms. Jonig. Ms. Hager.
Thank you. So briefly returning to the question assuming assuming the new Public Act is only clarifying the existing statute with no change, I do think you still have a problem in that the paragraph that's added does muddy the waters of the public policy stated within the Act and stated by Illinois law and other places, which is to protect the expression of religious expression in the workplace, where this paragraph now comes in and does the opposite. And notwithstanding the questionable interpretation of the appellate court on the effect of that amendment or that new section, it does have to be dealt with that now having this section in the Healthcare Right of Conscience Act contradicts the stated public policy of the Act, and then does on its face create an act that violates the right of workers to be free in the workplace from religious discrimination. And so based on that, we would ask the court to remand the case, revive the claims, remand the case for further proceedings so that plaintiffs can seek relief on their cause of action. Thank you.
Ms. Hager, thanks to you. Ms. Jonig, thanks to you. We will take the appeal under advisement. We'll move to our second argument of the morning. It's in appeal number 222731, Jack Morgan versus the Federal Bureau of Prisons. Makamova, good morning. Nice to see you. Whenever you're ready.
May it please the court, I am Shireen Makamova of Sidley Austin for appellant Jacqueline Morgan. The district court erred when it dismissed Mr. Morgan's claims at the pleading stage before defendants were served, but I would like to begin by addressing Mr. Morgan's standing for injunctive relief, an issue that was raised by the government on appeal. Mr. Morgan has standing to seek injunctive relief because there is a substantial risk that the prison will deny a kosher diet to him once again in the future. There are several reasons for this, and the government's arguments...
I have a question for you.
Yes,
is it that the prison will deny a kosher diet to him, or that the prison will deny him his choice of food? Yeah, I'm curious. But if you have a prisoner who says, I want kosher meals. I'm Jewish, I want kosher meals. Except I love cheeseburgers and I love turkey logs. Mm-hmm. So I'm going to eat turkey logs and I'm going to eat cheeseburgers. Does the prison have to say, okay, if your sincerely held religious belief is that you can be kosher and eat cheeseburgers and turkey logs, you're good?
Yes, Your Honor. I think this question gets to who gets to define what does the prisoner's religion require, and it's not the prison that gets to define what is kosher under Mr. Morgan's beliefs. That is what he gets to define. Now, it's a separate question.
So the prison has to feed him whatever he wants, is your position?
Our position is that Mr. Morgan's claim should be allowed to proceed at the pleading stage. Now, it's a separate question, if the government has a compelling interest to deny the cheeseburger, or if it is using the least restrictive means to do so, but those are factual questions that the government has to introduce facts and demonstrate, as required by the statute and the case law, that it actually has a reason to deny the cheeseburger. But if that's what Mr. Morgan's religious beliefs require, then at the pleading stage, that is all that is required of him to show substantial burden.
So then a plaintiff would always proceed past the pleading stage? Always?
As long as, pursuant to the well-established case law in the circuit, the plaintiff can show that he was denied a religiously appropriate diet, which in this case Mr. Morgan has. I think the only
according to his own religious beliefs. According to his own religion, what he classifies as religion, as long as it's sincere, and sincere we can't test at the pleading stage.
Your Honor, there is some case law that says that certain claims and beliefs are not bona fide religions, but that is not what the government has claimed here. There is no dispute that Mr. Morgan's religious beliefs are actually, accepted as a religion, even by the government, by the prison. So the only thing that we have here is that purchase of the turkey logs.
Yeah, I just wonder if the standing question is, as you defined it, by saying it's reasonably likely that he'll be denied a kosher diet in the future. If that's the question, or substantially likely, I wonder if that's the question, or if the question is he likely to be denied a turkey log in the future? What is the standing question?
I think the standing question boils down to, is he going to purchase a turkey log again? Because that then answers the question of, is this going to happen to him again? And
Yeah, or is he going to attempt? That might be right.
And Mr. Morgan has represented to council that, he will, consistent with his religious beliefs, purchase things from the commissary. We also have that in the record where in the complaint he said, I want to be able to, avoid this kind of treatment in the
Right.
future.
But is that the standing question? Will he just purchase a turkey log? Isn't the standing question more of, if he purchased the turkey log, are they going to preclude him from eating the kosher diet?
I don't think that's really the question in this case, Your Honor, because the government has not disputed actually that the policy under which Mr. Morgan was suspended has changed, or that he was suspended in error. All we know from the record before us is that somebody reported Mr. Morgan's purchase of the turkey log, and then he was essentially automatically suspended and provided
Well, I think
this
they
form.
have disputed the application of the policy and the fact that the chaplain has discretion, so there's not necessarily an automatic exclusion from it.
Your Honor, I think the government's arguments on that point ask the court to draw inferences that are contrary to Mr. Morgan, and that's just not what's allowed.
But
under
how is that?
Western law.
If you look at Mr. Morgan's complaint and the attachments to it, they talk quite a bit about the chaplain and the chaplain's role and the chaplain's discretion. So I don't think they're reading in anything into it beyond what's in the attachments.
I think we have to go back to the only official form that we have on the record here that was provided to Mr. Morgan, which is the form that notified him that he was being suspended from the kosher diet. And that form is phrased very definitively. It says you will be suspended, and you will be suspended for 30 days. And it does purport to give him 2 working days to meet with the chaplain, but we don't know from this record, Your Honor, when Mr. Morgan actually received that form, if he had the 2 days to meet with the chaplain, and even assuming that he did receive it on time, there's nothing in the record to suggest that he refused to meet with the chaplain.
But in his own allegations, and I think this was a grievance that he sent that's attached, he alleges that the policy is being abused by the chaplain to restrict the religious exercise of inmates, which suggests to me discretion at the chaplain level.
Your Honor, I think we have to remember that Mr. Morgan was proceeding pro se below, so we have to liberally construe all of his claims in his favor. And I read that language as Mr. Morgan's best attempt to describe sort of the injustice that happened to him. We don't even know on this record, because the government was not required to appear below again, what is the actual policy?
That was going to be one of my questions.
Right,
What
so-
is the policy?
So all we're asking for, Your Honor, is that Mr. Morgan be allowed to proceed and that the court require the government to appear. And the government can, below show to the court that its policy, in effect, either strips Mr. Morgan of standing, or that there are other factual questions that prevent Mr. Morgan from receiving relief. That's just not appropriate at the pleading stage and, before the government even had to appear in this case.
Ms. Makhmova, I got some questions on the injunctive relief.
Right.
He's pro se. He didn't have the benefit of your counsel here. But what he does say, as you know, in his handwritten complaint, he says 2 things as to the scope, at least as I discern it, as to the scope of the request that the relief he would like. He asked for the court to order the Federal Bureau of Prisons to discontinue policies governing the involuntary withdrawal of the kosher diet. And then he asks a question a little bit later on that is whether it's beyond the authority of the court to order the BOP to change its policies.
Right.
How do you interpret what he's asking for?
Your Honor, thank you for recognizing at the outset of the question that he was proceeding pro se. Our understanding is that if Mr. Morgan is allowed to proceed below and amend his complaint, that injunctive relief request could be sort of narrowed a little bit and fashioned in a different sense, and the district court also could narrow it. I think it would be appropriate for the district court, for example, issue an injunction that prevents the prison from sort of imposing its own definition of kosher and its own box of what Mr. Morgan is allowed and is not allowed to do. That would be appropriate, and that would be probably the narrowest injunction that Mr. Morgan can get in this case.
Okay, so it sounds like because as drafted, and again, I recognize he's not trained as a lawyer, there's some real breadth to what he's asked for. It looks facial, not so much as applied, and then it looks prescriptive
Right.
in the sense of, I'm not at all sure that we have the authority to require the Bureau of Prisons to promulgate new policies.
Of course, Your Honor, and we are not asking the court to affirmatively do that. We're just asking for Mr. Morgan to have a chance to proceed below, and the parties can sort of litigate
So your
that
point
issue.
is a narrow one. That is that he's alleged enough for imminent injury, and therefore it can go forward that way, and that he would welcome an opportunity to narrow his request for injunctive relief.
Exactly, Your Honor. And I just want to, yes, Your Honor.
Just to follow up on something you answered in response to the Judge Scudder's question, you said to narrow the relief, you would ask that the institution not impose its own definition of kosher as opposed to the Bureau of Prisons?
Your Honor, our position is that, and this is, again, it bears out in the case law, that the government does not get to define for the plaintiff.
I
what his
understand the
religion
position, I'm just
requires.
trying to understand the scope of the requested injunctive relief. And I thought I heard you say in response to Judge Scudder's question that if you realize that there might be some problems with the breadth of what's been
Right.
requested to have BOP
Yes.
change things. If I understood you correctly, the modification would be to direct the particular institution where he's serving his time to not impose its own definition of kosher.
Your Honor, I think it would have to be a little bit wider. It would have to be directed at the Bureau of Prisons because Mr. Morgan, his claims are based on a system-wide policy, and he has been moved from prison to prison during the pendence of his case. So I think it would be a little bit broader than that, but it would still be specifically applicable to him and to his understanding of what his religion requires.
That comes back to the breadth problem.
Yeah, the prison, he's in Terre Haute, right? Or he was at some point
Yes,
in
Your
Terre
Honor.
Haute. So I don't know. It's not in the record, and I'm not asking you. I don't have any idea how they implement the kosher diet policy there. I don't know if he's met with the chaplain or not met with the chaplain and said, this is an acceptable item for me. I'm looking for an exemption from the standard diet. So the fact that he is no longer in Thompson is complicating for him, not clarifying for him, at least in my mind.
I disagree because I think we have to go back to the form that was provided to Mr. Morgan as to why he was suspended. And that form has 3 checkboxes, and one of them says you violated your religious diet. That box was not checked by the government. The form that was provided to him simply said that he bought unauthorized commissary. Now again, from this record, because the government has never appeared below, we don't exactly know how does it define unauthorized commissary? How does it decide which box to check? But what we do know from this record, and just drawing all reasonable inferences is in Mr. Morgan's favor, we can say that he did not violate his religious beliefs, and the prison suspended him for some sort of disciplinary reason that is outside of what is kosher and what is not kosher.
Do we even know if Terre Haute has turkey logs?
I'm not sure, Your Honor, but I assume that prison commissaries have standard items across.
That might be a big assumption. I'm not sure.
Fair.
Doesn't that create a standing problem?
How so, Judge?
Well, if he claims he's substantially likely to be injured in the future by buying turkey logs, and they don't have turkey logs,
Your Honor, I don't think
What's the
Mr.
problem?
Morgan's claim is so narrow as to say, I want to buy specifically a turkey log. I think what he's asking for in this case is that he be allowed to act consistent with his religion. Because what happened here is the Bureau of Prison drew a box that said, this is kosher. Everything that's inside the box is kosher. And if you step outside that box, then we're going to discipline you and we're going to penalize you. And so it's not so much about the turkey log per se, it's about Mr. Morgan's religious beliefs and his ability to follow that religion according to his beliefs, not what the Bureau of Prison requires.
What if he wants to eat something that is clearly not kosher?
I think, Your Honor, that again goes back to the question of who gets to define what is kosher, and the prison does not get to define that for him. And we can dispute sort of whether the prison actually has to provide anything that he wants to eat, but that's a factual question, and the prison can demonstrate below that, it has a compelling interest not to provide the item.
I don't know that it's a factual question as to whether or not the prison gets to let him eat whatever he wants to eat. I mean, that sounds like a legal issue as to,
Yeah.
do they have to provide the specific type of kosher food he wants?
Your Honor, we're not asking the court to affirmatively hold that the prison has to provide the kind of kosher food that Mr. Morgan requires. We're simply asking Mr. Morgan to be able to proceed below to prove his claims. And I don't think this is actually, a question of law, because again, it goes back to the fact that Mr. Morgan has, the prison and, the warden were not required to appear below, so we're just working with a very limited record here.
You want to save the remainder of your time for rebuttal?
Yes, Your Honor, thank you.
Okay, very well. Mr. Sorgel, good morning.
Good morning. May it please the court. I'm Lowell Sturgill from the Department of Justice, representing the Bureau of Prisons. There are a number of issues in the case. I'd be happy to take them in any order.
At some point, if you could tell us what the policy is, if you know, that would be helpful.
So the first place to look is the regulation. There's the relevant regulation is cited in the Daly case from this circuit, and it's 28 CFR 548.20. And it basically says that if a prison finds that an inmate has violated a religious diet, the prison may, and that's the key term, the prison may suspend the privileges. So it's discretionary on the part of the prison, it's not automatic. And so that's at the regulations level. Then in terms of the institution, what happened in this case directly reflects that kind of discretion. The form that's key is page 7 of the appendix. The notification of inmate religious diet violation. This is the form that the chaplain provided to Mr. Morgan. And the key language in there is, if you look at there are two boxes, the box that has resolution, at the second lower box, it says resolution, and there's an explanation, there's a paragraph there. And it starts right off at the beginning. This is a notice of intention to be removed by the chaplain. It's not a notice that he has been removed or automatically would be removed. And then if you read on, if you believe this report is an error, please schedule an interview with the chaplain. And please do so within 2 days, because you notice the form is dated 2 days before the suspension was set to occur.
Yeah, I'm thankful that you're raising this point, because you mentioned it in your brief as well. And the question I have is, are you making, is it the BOP's contention that he was under a legal obligation before going to federal court to sue to take up the chaplain on that invitation? And if so, what's the source of the legal obligation?
Well, the legal obligation is he's brought a claim under RFRA, of course, and then to make a prima facie case under RFRA, the plaintiff has to show a substantial burden on the free exercise of religion. Our point is the simple one that if he had an opportunity to talk to the chaplain before he was suspended and explain why he shouldn't be suspended, that's a ready alternative that defeats a claim of substantial burden. And we've cited a number of cases from the circuits on that support that point. So that's where the legal obligation comes in. Now, you've heard this morning and in the opening brief by counsel that supposedly there's no proof in the record that he actually received the form prior to the suspension. But one thing, I think the most important thing to note, is he's been willing to make all sorts of representations in his new counsel written brief about things that are not in the record. For example, it's never been in the record that he thinks a turkey log is kosher. That's something you see for the first time in the brief. He's willing to represent that. But what you don't see, he doesn't represent that he didn't get the form 2 days before the suspension occurred. So he knows when he got the form, and we know that we gave it to him 2 days before. So the fact that it's not in the record, he's got to,
Is there a standing problem here for him because he's now in Terre Haute?
So it is the case that The record doesn't show what's available to him at Terre Haute. We don't know if, I don't know myself whether they have turkey logs or not. But I think the one point I wanted to make is he was removed from the religious diet in June of 2021. He was put back on 30 days later. He doesn't allege that he's ever been taken off again, that he's ever had any problems getting just whatever he wants to eat, wherever he is, whether it's in Thompson or Terre Haute or anywhere else. You'd think that he's willing to make all these representations about what he's willing to eat and not for the first time on appeal. He would tell you.
Well, the
that he's
litigation,
having a
though,
problem.
gets static at some point in time. He files a complaint, it goes through the district court, it comes to us, right? I mean, he's not sending us daily correspondence about his experience in the jail.
Well, he seems to be by offering for the first time in his Court of Appeals brief what he's willing to eat and what he's not, and what he thinks is kosher and what he's not. That wasn't before the district court. What happened in the district court is he filed really an astonishingly broad complaint. And what the complaint says is that no matter what I do, you can't take me off the special religious diet. That's what he says. And if you look at the administrative remedy request that he submitted to show that he exhausted his religious beliefs, his administrative claims, it says the same thing. It says,
Do you
can't
agree
take-
if he had been punished for eating something that he sincerely believed was kosher by being removed from his kosher diet, that would have been a violation of the statute?
So not here again, because he had an opportunity to explain to the chaplain why he shouldn't have been removed from the diet. He didn't take advantage of it. That's an alternative that was available to him, and that demonstrates.
What if that alternative had not been available to him?
Then I think it's a different case,
Yeah,
and
then-
maybe he can show a substantial burden.
But would that alternative be a factual issue?
So, not in this case, because again, he hasn't even alleged that he didn't get the form in time. He says that the record doesn't show it, but honestly, I think he's being a little cagey here. He says, okay, I think turkey is kosher for the first time on appeal, but he won't tell you whether he actually got the form, which he put the form in the amended complaint, right? We didn't put that in the record. He put it in the record. So I think
That doesn't necessarily answer when he got it, though.
that's correct. A few other. So anyway, he's making what the claim in the case is astonishingly broad, and there are cases that I believe are even cited in the House and Senate reports on RFRA, where prisoners wanted to have steak and wine, and my religion says I have to have steak and wine, every week, and that kind of thing. Prisoners do, right? I'm not anti-prisoner, but they will do what they can. So, and the courts say, well, that's clearly not religious. That's not what RFRA was meant to allow, but that's essentially where he puts you. And I think that.
Well, the turkey log's a little different than steak and wine.
Right, I'm making steak and wine as kind of an illustration of where this would lead, and what if you take his claims to the logical conclusion, that's where you end up. He gets to do what he wants, and the prison can't ever take him off the special religious diet. That's what his complaint
Well,
says.
there's a second part of the test in terms, it's not whatever he wants goes, right? The institution gets to respond to that as far as the burden it would put on the institution, the availability of certain items, et cetera.
Right, so even
I mean,
if,
that's why the filet mignon cases fail. Because even if somebody comes in and says, this is part of my religion, I have to eat steak every other day. Great, it's part of your religion. Doesn't mean the steak is going to be delivered.
so that is true. I do think some of the steak and wine cases also say this is so outrageous that it's just not a sincere religious belief. So I think we win under either prong.
Yeah.
That was my point about the turkey log, though. That's not. Some places acknowledge or consider turkey kosher. So to question at the pleading stage the sincerity of eating a turkey log sounds like an issue of fact to me.
So that's why in this case the form is important, because he was not actually removed from he caused his own removal by not going to the chaplain and saying, oh, by the way, my religion says I think that a turkey log is kosher. He never did that. So that's why they removed him.
What does
And-
unauthorized commissary mean?
So
That's
mean-
what the box, that's the box that is checked.
So the first thing to know is that the form itself, which I could find in a minute, but the top of the form says, it's a notice of inmate religious violation. So the whole form is talking about what happens when the prison determines that an inmate may have violated his own religious beliefs. So unauthorized commissary means what happened was the chaplain went through the records of which inmates had purchased which items from the commissary. They found that Morgan had purchased a turkey log, which is not kosher. So then the chaplain said, "Oh, please come in and explain to me what's going on. Do you still, as you look at the form, what it says is, do you still need to be on this special religious diet because you seem to be eating things that are not kosher?"
Yeah, I mean, what you're not using these words, but you're basically saying because of that outlet available to him with the chaplain, there's an embedded exhaustion requirement.
So, I mean, I wouldn't put it that way because RFRA doesn't have an exhaustion
No,
requirement.
it's functional. It's kind of functional. It's exhaustion, right? I mean, he had your point is that he had this alternative outlet. What's the outlet? Go talk to the chaplain, have a discussion about your diet, and see if you can get an exemption or some relief from the way the policy is being currently implemented. He didn't do that.
So I think that's right. I think we would much prefer you reach that result under the substantial burden prong of RFRA because I think that's where it fits,
Yeah.
given that RFRA doesn't have an exhaustion requirement. But you're right.
Why not under the standing prong?
Oh, that too.
Why not under the standing prong?
Yes,
It
that's
was not substantially likely to occur again
exactly.
because he didn't afford himself these available opportunities. There's a difference between a turkey leg and filet and wine, right? I mean,
Right.
it's possible that look, it's possible that somebody who is Jewish and eats a kosher meal or an individual may define kosher different than, an individual here may define kosher different than an individual living somewhere else. I mean, according to their religious practices. And he can explain that to the chaplain. And perhaps the chaplain will agree or will disagree.
Exactly.
But he can't say that it's substantially likely that he's going to be suspended again without having afforded himself the opportunity to take advantage of the program that the prison allows to create an exemption.
Yes.
That's the way I understand the standing argument.
Yes, that's it.
Yeah,
And there's
go ahead.
there's a different chaplain now as well, correct, at Terre Haute?
Right.
Yeah,
I
the
have
Terre Haute part of this adds complexity to
Yeah.
it.
It does.
So, or at least complexity from his perspective, in my view.
If I could, Your Honor, I have 2 minutes and a little left, and there's a second big issue in this case that they've raised, which is whether the RFRA waives the United States sovereign immunity for damages.
Right.
I don't want to sit down with at least getting to that and ask if you have any questions that the basic point is that every circuit that's addressed this question has held that RFRA does not waive the United States sovereign immunity for damages. In Sossaman, the Supreme Court held that RLUIPA, which is a sister statute to RFRA, does not waive the state's sovereign immunity. And what Supreme Court said is directly applicable here. The court said appropriate relief, which is the key term, is open-ended and ambiguous about what types of relief it includes. The context here, whether the defendant is a sovereign, suggests, if anything, that monetary damages are not suitable or proper. So that rationale maps directly onto RFRA, as all of the circuits have held. For that reason, we believe that.
And your added point, I think, correct me if I'm wrong, at least I took this away from your brief, is that Tanzan versus Tanier doesn't change that at all.
That's correct. In fact, Tanzan drove the last nail in the coffin of this by saying that quote, the obvious difference between damages versus individual federal officials, which was the question issue there, and the federal government itself. That's about as strong a signal from the court as you get for an issue that wasn't in the case. The plaintiffs rely on 2 cases, Clark versus Martinez and Santos, which say that typically courts don't read a single term in the same statute to mean two different things in two different contexts, but neither of those cases was a sovereign immunity case, and sovereign immunity is different. You have to have a clear waiver. They also ask you to reinstate the individual capacity claims against Warden Scioli. I represent him in his individual capacity. The court shouldn't do that. As the district court correctly held, he was named in the caption, but the body of the complaint never said anything about him and what his personal involvement was. And with that kind of allegation, that he cannot be added back in, and he did a complaint, he did an amended complaint. The district court said, I think we've seen enough, he's done the best he can, and so for that reason, you shouldn't reinstate the claims against the warden. I have all of 10 seconds left, which I don't really have anything extra unless...
No, we understand your position. We thank you very much, Mr. Sergel. Okay. We'll give you a couple minutes on rebuttal here.
Thank you, Judge Scudder. I would like to address this issue of the form providing an opportunity, allegedly, for Mr. Morgan to meet with the chaplain. So the government just conceded that if Mr. Morgan was not given an opportunity to meet with the chaplain, then that would be a different case. And our argument is that that is exactly the case here. Black letter law requires the court to draw reasonable inferences in Mr. Morgan's favor. If the court concludes today that Mr. Morgan had an opportunity to meet with the chaplain but declined that opportunity, it would be drawing inferences against Mr. Morgan, and that is simply not allowed.
What about the inference going forward? Now that we know what the form says, Mr. Morgan knows what the form says. The form clearly says you can meet with the chaplain.
Right.
So from a standing standpoint, you may have a solid argument on the event that's already occurred, but going forward from a standing standpoint, how do you get around that language?
Your Honor, one of the points that we still don't know, whether going forward or in the past, is when is this form actually delivered? Does the person have 2 days to actually meet with the chaplain? How does the interview go? There are all these questions that are unanswered.
But this form clearly says, talk about future only, again, for standing purposes. This form clearly advises him that he has the opportunity to meet with the chaplain for an interview within 2 days to determine whether or not suspension is appropriate.
I think Your Honor would have to assume, again, that Mr. Morgan would actually receive the form on time and have the opportunity to meet with the chaplain, and the record just does not bear that out. That's all that I have. Unless Your Honors have any more questions, we ask that the court vacate the judgment and remand the case for further proceedings. Thank you.
Okay, very well. Ms. Makamova, I see here that you took the case on appointment from the court,
Yes,
correct?
yes, sir.
We very much appreciate that. You've done a very fine job. Mr. Hockman, it's nice to see you. We appreciate your firm accepting the appointment, and we'll take the appeal under advisement.
Thank you, Judge.
Our third argument of the morning is in appeal number 24-1751, Waukegan Potawatomi Casino versus the City of Waukegan. Good morning, Mr. Smith.
Good morning, Judge Scudder. May it please the court, Dylan Smith for Waukegan Potawatomi Casino, which I'll be referring to throughout my argument as Potawatomi to keep things simple. And if I may, I propose to take things out of order and begin with the merits of Potawatomi's equal protection claim. And I want to do that in part because once this case was removed to federal court, I was the lawyer who was principally responsible for litigating it below, and so I'm familiar with the record, which I think is a little more important for that claim. If time does not permit us to get back to the Section 1983 claim, as you've seen from our papers, we do believe that the district court's analysis is flawed in multiple respects, but we are comfortable resting on the papers if that's where we end up. Let me just say at the outset on the equal protection claim, I don't believe that there's a significant dispute between the parties about the standard that governs class of one claims generally. where the district court went astray here, the fundamental problem with its analysis is, bless you, Judge Kirsch,
Thank you.
is the failure to identify the discriminatory conduct at issue and apply that standard to that conduct as framed by Potawatomi and the evidence in the summary judgment record.
Before we get to the discriminatory conduct, there's a hurdle to get through, and that's the similarly situated, which is very important in Class of 1 claims for obvious reasons. And we have said you have to be identical in all relevant respects or directly comparable in all material respects. How was your client similarly situated here? How were the proposals submitted by it?
Yeah, thanks, Judge St. Eve. The key term there is in all relevant respects. And when I put the focus on the need to identify the discriminatory conduct, that's important for both prongs of the Class of 1 analysis, both the conceivable rational basis and the similarly situated requirement. Because until you've identified what the discriminatory conduct is, you don't really have a basis, a firm foundation for deciding whether the distinctions that are being drawn justify the difference in treatment. And that's why it's relevant respects. And that's why that issue is really generally should be an issue for the jury, because you need some factual finding as to what you're talking about. So to take this case and to answer your question more directly perhaps, it's our contention that there was a rigged process culminating in a sham vote where Potawatomi was systematically disadvantaged throughout the process. And a large part of that discriminatory conduct involved filtering out information that tended to put Potawatomi in a stronger light relative to its competitors.
Are you suggesting that in looking at similarly situated, we should not be looking at the proposals that were submitted?
I'm saying that actually is the wrong framing, yes. And I think
So
that,
if we are not looking at the proposals that were submitted, what do you think we should look at for the similarly situated?
Sure. So if you take what our allegation is, which you have this process based discrimination. So from the get-go of this process through the culmination, basically it's going to be, and I will concede this, in some respects a relatively low threshold. You have a qualifying proposal, you have an admittedly qualified candidate that made its way through the entire process. Let me give a counterexample to try to put some concreteness on this. This is not a case where Potawatomi was weeded out at some earlier stage of the process where the city said, you know what, you're not a credible candidate, we're not moving you on to the next round. They made it to the end round. Some of the information that was selectively withheld from the city council in this case went to the very issue of the qualifications of the applicants. So there's no rational basis for distinguishing between these applicants in the way the city did.
So are you saying for the similarly situated analysis, we look at the applicants and not their applications for the casino proposal?
I think for the relevant, for the similarly situated in relevant respects, you start with what's the alleged discrimination? And you say here, were there differences among the applicants and their proposals, but let me qualify that, in kind of a threshold way that justified treating them differently in the way the city did. And at this point, the discrimination starts from a very threshold, the threshold of the selection process. So for example, Potawatomi has a very strong balance sheet. That information doesn't make its way into the consultant's analysis, doesn't make its way to the city council. There is information that is very critical about the proposals the city council is ostensibly voting on. Here's a specific example from the record, and I don't want to get too far into the weeds here. But North Point, which we say was really the favored candidate here, they submitted something to the mayor's administration that says, look, we're concerned when we get to the gaming board level, we're going to have to bid for that license once you hand it off. And we're concerned that other applicants could outbid us. And we've tried to be very generous to the city. So if you certify multiple applicants, our proposal is going to be will match the least generous financial consideration to the city, including as to the consideration to be paid for the land, the share with the city, etc. There's no rational basis based on the different qualifications of the applicants or their proposals from withholding that information from the city. So in this case, once you identify the discriminatory conduct, what you're really looking at is, do you have qualified applicants who are participating in this process, who have submitted a conceitedly qualifying proposal, who are conceitedly well qualified? They made it to the end stage. The city is filtering out information before there's any consideration of proposals. So the differences in the proposals really are kind of beside the point when you look at the discriminatory conduct.
I understand the argument. What's the best evidence, though, that this was rigged, that the stack was, the deck was stacked, manipulated, that this was really, Mr. Bond had all of this on puppet strings?
So Judge,
that's the contention.
And I could go on for a while about this. Let me hit some high points. And I want to, and I'm not saying this to not answer your question, but I want to make clear about something. Some of this evidence will go to motive, some of it goes to irrationality. And I want to be clear, our position is, first you need to demonstrate irrational conduct, and then motive. But let me give you an example. What you have here is a process playing out that is reacting to public scrutiny. So this evidence was actually really strong, and when you read the district court's opinion, I urged the panel, and I know you will, to dig into the record a little bit and the statement of the case in our briefs and the summary judgment record. Because I think because the district court started off with the wrong framing, you mostly get our theory of a rigged case jammed into a footnote too that, in fairness, doesn't read the facts in the light most favorable to us, presents our theory fairly crudely. Let me give you an example. Part of our theory here is that the mayor intended to favor Michael Bond, who's the principal of this North Point, okay? And what happened was at some point there was public scrutiny because there was a lawsuit, because a reporter started snooping around and asking questions. We actually got the reporter's email in the discovery, okay? Up to that point, now every municipality that's done this, everyone realizes they're not equipped to evaluate casinos. They have outside consultants. Chicago has outside consultants, Rockford, whatever. The city wasn't doing this with an outside consultant. The mayor put together a casino review committee. As his point person on that committee, and this is in the record, he put a mayoral aide who had been introduced to him by Bond because that mayoral aide had been an aide to Bond when he was a state senator and had been an employee of Bond's video gaming company. Okay, then there's scrutiny. There's an outside consultant brought in, and all along the way, anytime there's information that tends to favor Potawatomi relative to applicants or put other applicants in a unfavorable light, that gets manipulated. So the fact that, for example, Full House doesn't include job projections. They get invited to patch that up. There are all sorts of things about their financials that don't end up in the consultant's report.
That you guys weren't able to supplement from the plus or minus percentage
well,
thing?
What the consultant said was, I can't factor that into my analysis, okay? And it's against the rules to provide any supplementation. And so we didn't consider any supplemental information. That's just, one example here. But it left the city council with the impression that somehow Potawatomi was trying to violate the rules. It also left them with the impression that they hadn't taken supplemental information from other applicants. That's different treatment. The city council didn't know, had no idea that North Point had conditioned its proposal on being the sole selection. So they're voting on a proposal that's totally illusory. That's part of the reason.
Doesn't your theory fizzle, though, given that North Point didn't get the casino?
No, absolutely not, Judge, because our theory, and this is where I think, respectfully, the district court portrayed our theory a little too crudely, okay? The discrimination was an effort to limit competition for North Point. And no one knows, North Point did get passed along to the gaming board. No one knows what the gaming board's going to do. And one thing, if you look in the summary judgment record, again, there's a consistent concern about the ability to bid for the license at the gaming board level. And our allegation is not just that there was, Bond whispered in the mayor's ear, who whispered in the city council's ear and said, this is how you're going to vote. Our theory is Bond was the guy, North Point was the proposal, and then there starts to be public scrutiny. And so the mayor knows, look, this is not happening in a vacuum. It becomes clear he can't just, the city can't just certify North Point. And part of our narrative here that's well supported by the summary judgment record is that relative to Potawatomi, Full House has weaker financials, has a bank reference letter that's nothing, it's balance sheet insolvent for the previous 3 years. None of that makes its way through into the consultant's report. And so our theory of the case is actually what the mayor and the Bond-backed city council members were inclined to do once it became clear you can't just certify one, is to limit competition for their favored candidate, which ended up being the discriminatory conduct against us. The fact that,
So I come back to what I asked
Yeah.
you earlier. Why isn't the similarly situated analysis then done on your submission and the submission of the 4 companies that were attempting to get the casino?
Yeah, because the discriminatory conduct doesn't relate to just the consideration of proposals and isn't justified by the consideration of proposals. It's not what triggers it. It begins well before then. And in fact, our whole theory of the case is that the consideration of proposals was corrupted by the way information was siphoned to the city council. So, that's why when you get back to it, you've really got to identify what the discriminatory conduct is. Let me give an illustration that I think kind of highlights the problem here with the way the district court approached it. And I think Judge St. Eve hopefully goes to the point you're getting at here. Take a solicitation for some sort of public project, a solicitation for proposals, and assume that there's going to be, some discretionary choices to be made, whatever the project is. It's not, a solicitation for rebar or something like that, okay? And assume that for some illegitimate reason, an agency official wants to favor one competitor over a disfavored competitor. And one way to do that, and this is, well known in the bidding world, is to provide non-public information to the favored competitor, to the disadvantage of the disfavored competitor. And suppose the favored competitor wins. Under the district court's analysis, the defendant's going to be entitled to summary judgment. Because you can look at the proposals and the selection of proposals in isolation, there's going to be conceivable rational basis, but it completely misses the point. And to just look at, and by the way, this matters both for the rational basis and the similarly situated requirement. So I had wanted to save some time for rebuttal. I realize I'm...
Yeah, we'll give you a minute on rebuttal. If you
Okay,
want.
I appreciate that.
Yep, you're quite welcome. Okay, Mr. Insler, good morning.
Good morning. May it please the court. Charles Insler on behalf of the city of Keegan. The Potawatomi are a disappointed applicant. They are not the victims of intentional discrimination. And the reasons for this lawsuit are transparent. Their own casino expert, John Repa, calculated that a casino in Waukegan was going to cost the Potawatomi's flagship casino in Milwaukee $32 million a year. One of their consultants also said that killing gaming expansion was the long-time Potawatomi position. And their own CFO said that putting a casino in Waukegan was going to be a high-risk venture with difficulty in financing and profitability. So the Potawatomi are not here on a genuine basis. They always wanted to kill a casino in Waukegan to benefit their flagship casino in Milwaukee. Now, Judge St. Eve, you asked about what is the comparator here? And the comparators are the proposals. The city of Waukegan was voting on proposals, casino proposals. They were not voting on a process. And so you need to look at what proposals each applicant put forward. And those proposals are in no way similarly situated. This court's decision in Paramount Media said, when you have two offers for land property, one is a lump sum of $800,000 and the other is an offer for $1.14 million spread over 40 years. Just those two differences mean that the two applicants are not similarly situated. And in this case, we have a litany of reasons in which the proposals were different, the candidates are not similarly situated. And I think the Crosby case from the First Circuit with the Justice Souter opinion is particularly telling because in that opinion they say, just given the absolute breadth of discretion when you're choosing casino applicants, it's almost impossible to have proposals that are similarly situated. And the facts bear that out in this case. You're talking about proposals that differed in square footage, design, architecture, the number of gaming positions, aesthetic, hotel, entertainment complex, temporary casino. And all of those are very important factors and points. So let's take square footage. The Potawatomi's proposal was 130,000 square foot for a casino. It was bigger than the next largest proposal by 55,000 square feet, full house. And yet John Repa, the Potawatomi's expert, said the Waukegan market is pejoratively, it's a grinder market. It's a meat and potatoes market. So what would you be doing putting a casino of that magnitude in Waukegan? It didn't make any sense. Now, some of the other proposals included hotels and entertainment complexes. The Potawatomis did not. They did not have a temporary casino, they did not offer an entertainment complex, and they did not offer a hotel. And let's look at the importance of a temporary casino, because right now, there's no casino, there's no permanent casino in Waukegan. All we have is the temporary casino. But that temporary casino is generating millions of dollars in revenue. $4.5 million in revenue this year, based on the Illinois Gaming Board reports. That is millions of dollars going to Waukegan. And under the Potawatomi's proposal, there would have been no temporary casino, and so the city would have lost out on that $1 million of tax revenue. So that's another important factor and another important difference. And Alderman Bolton said, that's an important difference to me. So these are not just conceivable reasons, but actually well-supported reasons from the record. There's a somewhat situated hurdle, and there's also the hurdle that this court has to find that there is no conceivable rational basis for treating the proposals differently. And the district court laid out 6 distinct reasons for treating the proposals differently. And those are both supported by the record and absolutely conceivable. And they don't negative any of those 6 reasons. What they want to do is they want to put the animus before the rational reasons, and they can't do that under the law. The Seventh Circuit has consistently said, we are not going to get to animus, we're not going to get to motivation until you can negate every one of the conceivable rational bases for the difference in treatment. And in the court cases where we do find no rational basis, those are cases that involve ministerial duties, where there's absolutely no discretion involved. So we see in Brunson, where the mayor hires a hitman basically to rough up the plaintiff's liquor license. In Brunson, there was no discretion. The mayor had to approve these liquor license renewals, and he did not. In town of Cicero, it was involving condominium redevelopments. The plaintiff was not getting his building inspections, even though he was passing all of the permitting requirements. So, and in Frederickson, the sex offender was trying to move from one town to another, and the city was not forwarding the leads files. And the witnesses in the Frederickson case said, we've never seen this. In 19 years of doing this, we've never seen this happen. And so when you have absolutely ministerial functions where there's no discretion, that's when you can say, look, there's animus. But where you have a casino application process, where there's conceivable rational basis for choosing between different candidates, where there's a breadth of discretion, then you don't get to motivation. But I think it is worth touching on motivation, because that's their case, right? Now, their case is basically, it's illogical, right? If the fix was in, if the city of Waukegan always wanted to have North Point and Michael Bond be the lead applicant, then why on earth would you choose 2 competitors? That doesn't make any sense. And obviously, North Point wasn't even chosen. It wasn't that this ProPublica article came out, and so there's all this news coverage. In the early 2000s, the city of Waukegan had advanced one candidate to the Illinois Gaming Board. And the Illinois Gaming Board did its due diligence and found that it was not a suitable candidate. And so the city of Waukegan had put itself out there with one applicant and had regretted that decision. And so it was very well mentioned and very well noted that this time around, the city of Waukegan was not going to advance just one applicant. They were not going to put all their eggs in one basket. And so it's not the ProPublica article. This was a long-standing position, having been burned once before, that the city of Waukegan said, we're going to advance more than one applicant as a hedge. That's what happened. The Johnson Consulting reports, they sought clarifications. They wanted to make an apples-to-apples comparison of all the proposals for the benefit of the city council. So they were not permitting supplementation. That's the difference. That's the major distinction. And ultimately, the Potawatomi were allowed to say, look.
But they did it. They did permit supplementation with respect in at least one instance, right?
No, there were clarifications. The supplementation that the Potawatomi sought with this plus or minus 15% of the appraised value, that information did go to the city. It did come before the city council. But in the formal Johnson Consulting report, Potawatomi's number was the plus or minus 15% of the appraised value, which was a $5.6 million appraisal. And then with respect to the North Point offer, in his deposition, Robert Long said he did not forward the North Point proposal because he thought North Point was seeking an unfair advantage. And so his motivation was equity, but not discrimination, not differential treatment. And Malcolm Chester, the Potawatomi's consultant, said, the reason we lost was because the city council was not well informed on the proposals. He made no mention of Michael Bond and no mention of discrimination. That's their own expert, their own consultant. In FKFJ, this court said, you can have a tapestry of colorful facts, you can have a complex situation, that doesn't mean you have intentional discrimination. And this same court, FKFJ, says, an absence of perfection in the process also does not mean you have intentional discrimination. So this was a complex process under extreme time conditions. And the city council members said they did the best they could under the circumstances. And to a person, each council member in their deposition said, I voted independently. Nobody told me how to vote.
Mr. Insler, can I just ask you one question about the 1983 point?
Yes, Your Honor.
Just trying to understand the position in your brief. Is it your position that in 100% of the cases, an Indian tribe or an affiliate, an arm of the tribe, has no rights under the Equal Protection Clause?
I think for the purposes of the 1983 claim, we know that a sovereign cannot sue to vindicate a sovereign right. And so the question is twofold, really. Would the Potawatomi be vindicating a non-sovereign right, and do they get to do that? And I think if you look at their own brief in Thurman, which is pretty telling, they say the tribes do not qualify.
Forget the facts of this case,
Okay.
though. First, I was just so I think you're right. No pun intended there. To focus on the right that is being sued for, but that seems to be a distinct question from whether the plaintiff is a person within the meaning of the statute.
So your question is whether a sovereign is a person within the meaning of the
No.
statute.
They're two different questions. The right that's being vindicated or sought to be vindicated in a 1983 action is a distinct question from whether the putative plaintiff is a person within the meaning of the statute. Okay. So suppose for example that you had a fictional city. Okay, I'm not talking about anything here. Okay, a fictional city that refused a proposal from a tribe on the basis of the tribe's religious practices. Okay, or on the basis that the tribe had a male or female chief, or something like that, right? The right that would be at issue would be equal protection.
So I think our
right?
position.
And that does not seem to say that does not seem to answer the question of whether the tribe is a person or not.
I think our position is that the Potawatomi or a sovereign nation cannot sue under Section 1983 because the meaning of the word person has to be given the same meaning at the beginning and the end of that sentence. And so that's the position that the Fourth Circuit took in Reinhold.
Yeah, that's the symmetry point.
Correct, that's our position, Your Honor.
Okay, all right.
I want to briefly point out that just this year in Hammond redevelopment, this court affirmed a motion to dismiss where the city said we had a rational basis for an eminent domain proceeding despite allegations of punishing political rivals, which are the exact allegations we have here. And that was at the motion to dismiss stage, before we had, 20 depositions in this case where every city council member was deposed and said on the record we were not discriminating against the city of Potawatomi. So in Hammond redevelopment, just from this year, it was enough on a motion to dismiss to say we can find one, and it was only one conceivable rational basis for the taking at issue. And this case gets dismissed because this is not a viable class of 1 case. Unless the panel has any other questions, I'll conclude.
Okay, not hearing any. Mr. Insler, thank you very much. Really appreciate it. Okay, Mr. Smith, we'll round that up to a minute for you.
Thanks, Judge. I'll try to get 2 quick points in the minute. First, as I said, we understand there has to be evidence of irrational discrimination first, and then you get to motive. And that's what Hammond Development said. You don't get to kind of look under the hood and say, well, I know there was a seemingly legitimate basis for this government decision, but, you can look into the heart of this official and, he doesn't like the cut of my jib. We've got that here.
But you don't get to that if there's a conceivable rational basis.
Right.
That's what Hammond said.
Right, and what there is no conceivable rational basis for here, and again, rational basis is shorthand for a legitimate, rationally related to a legitimate government interest. The evidence here is very strong that the city selectively funneled information to the ostensible decision maker about these proposals. And what counsel said respectfully is at best a matter to be decided at trial. And I would refer the panel to paragraphs 48 and 49 of the Statement of Additional Facts that Potawatomi filed on summary judgment. If you want to see, one remarkable piece of evidence we had was kind of a raw spreadsheet that the outside consultant had prepared, collecting everything that the mayor saw, and you can compare that to what ends up in the consultant's report. There was not just clarification, okay? Full House had no job protections in their proposal. That was ostensibly a central part of this request for proposals. The city said, hey, could you guys fill that in? And that's my last point. This is not a summary judgment case, okay? The more you dig into the record, we have a coherent theory about why there were multiple applicants certified, and we have evidence to back that up. Those rationales that the city council members gave about why they voted as they did, that wasn't contemporaneous. That was in their deposition testimony. And please don't just look at the defendant's statement of facts, look at our response to that. And the fact that there was a triable issue about whether those city council members testified falsely about why they voted as they did is indeed a window into motive and indeed a window into the irrationality of this. Sometimes as a plaintiff's lawyer, you plead a case in good faith, you get the discovery, you kind of have to squint to see it. We just kept getting good stuff in this case. So I urge the court to dig into the record.
Okay, Mr. Smith, thanks to you. Mr. Insler, appreciate your advocacy as well. We'll take the appeal under advisement.
Thank you.
Okay, our 4th argument of the morning is in appeal number 24-1530, the International Brotherhood of Teamsters versus Republic Airways and others. Mr. Wilder, nice to see you. Good morning.
Good morning. May it please the court. William Wilder for the Teamster Union appellants. The union's appeal from the district court's dismissal of their action under the Railway Labor Act, challenging separate individual employment agreements entered by the airlines. On the one hand, at Hyannis Air, a 3-party agreement among the airlines and new hire pilots there, and then separately Republic Airlines' own new hire individual agreement. district court held it lacked subject matter jurisdiction because the disputes were, quote, minor disputes under the Railway Labor Act that required arbitration.
Mr. Wilder, in the interest of time here, do you agree that the test we're applying is what's set forth in Consolidated Rail Corporation, whether or not this is a major or minor dispute as defined there?
Yes, Your Honor, there's no dispute about
Okay.
the applicable
Okay.
standard for determining.
And you
the
agree that the question then is whether or not the airlines have arguably justified their basis for doing what they've done here under the collective bargaining agreement?
Yes, Your Honor.
Okay, thank you.
I had the same question. I'm not going to belabor the time, but it's very hard from your blue brief to figure out what you think the controlling legal framework is. It's hard. I'll just say that. When you get to the reply brief, you see some passing references to Conrail, but I couldn't tell from the blue brief whether you think Conrail remains good law or not good law.
Yes, Your Honor, Conrail remains the governing law, and
So
this
now
issue.
we can frame the appeal within the Conrail arguable justification parameters, and then we'll have a debate about that.
Yes, Your Honor.
Okay.
Yes,
All right.
Your Honor. And so the union submit the district court, they pled adequate facts to establish the district court's jurisdiction, and that the airlines did not have arguable contract justifications for their positions. First, under the Hyannis Air Agreement, in which unions would submit, that has to be determined only under the established meaning and practice of the Hyannis Air contract.
And you're not arguing that the airline's position here is in bad faith?
No,
Is that-
Your Honor.
Okay. You're saying it's frivolous?
It's not, it is not arguably justified in that the established practice, for example, at Hyannis Air, as the unions alleged, is that the airline has agreed it may not adopt a bonus scheme for its pilots absent the union's agreement. And that factual allegation alone is sufficient to establish a major dispute at Hyannis, because that meaning of the Hyannis CBA, the agreement the parties, the defendants have entered, clearly violates that established meaning of the Hyannis CBA, and the unions submit, the district court erred in relying on the meaning of the Republic Airlines CBA and Republic Airlines rights under its separate agreement to establish a minor dispute at Hyannis. That may only be decided, established under the Hyannis agreement. And so that asserted justification by the airlines cannot be arguably justified, given that they
It can't be arguably justified on Hyannis's part under the management rights clause.
No, Your Honor, because that, like every other part of the collective bargaining agreement, is subject to Hyannis's acknowledged and conceded agreement that occurred in the 2022 bargaining, that it may not adopt a bonus agreement unilaterally without union agreement. And
Okay,
so
where
its
can we
management-
find that acknowledgement and or concession as you're talking about what you just said? Where can we find that?
That's alleged in paragraphs 41, 42 of the amended complaint, Your Honor. Now, as I mentioned, that alone is sufficient to establish a major dispute at Hyannis. As to Republic, a arguable contract justification cannot be based on an argument that either violates the clear language of the agreement or renders it meaningless or superfluous. An arbitrator can't do that without being subject to the award being vacated, and therefore an arguable justification cannot be based on that. And as to Article 3.0 of the Republic IBT agreement, it lays out 3 different types of incentive programs for 3 differently defined eligible employees. And this individual agreement violates that structure and its plain language by granting to new hire pilots who, under the language of Article 3.0, are only eligible for the incentives under 3.01, the incentives established under 3.03 for captain upgrade that are reserved for qualified pilots. And so that cannot be arguably justified because it conflicts with that clear language, and it effectively subsumes 303 into 301 and renders the separately established scheme under 303 superfluous. And so on that basis, it cannot be arguably justified under the clear and unambiguous language of the agreements.
Is your
and-
point with respect to the 41 and 42, I don't want to bog you down on that a little bit, that relates to the so-called pathway agreement?
Yes, Your Honor. That relates to the three-party pathway agreement that applies at Hyannis.
Okay, but Republic is paying, at least as I understand the facts or alleged facts, Republic is paying that signing bonus, right? And is that where you say, well, it may be as a technical matter that Republic is paying it, but Republic is acting as an agent of Hyannis?
Yes, Your Honor, because
Is that the argument?
yes, Your Honor, because Republic concedes it's not their employer, and that these pilots may never become employees of Republic. So it's paying them that bonus while they're Hyannis employees. It's acting as an agent of Hyannis, and then under the applicable terms, Section 2 first, Section 2 seventh, and Section 6, it is bound by Hyannis's status quo obligations.
Did you
as
make
an
that
agent.
agency argument before the district court? I didn't see it.
Yes, Your Honor. I mean, I believe we did, yes.
I'm not sure.
And the last point that I would make, Your Honor, is as to it's a separate doctrinal issue under the Railway Labor Act, under railroad telegraphers and its progeny. But we'd simply say that these agreements clearly establish inconsistent terms from subjects covered by the collective bargaining agreement. In essence, you've got pilots, one covered by the agreement, one not, operating under different terms in the same cockpit. And that violates the Railway Labor Act under the doctrine of railroad telegraphers. If the court has no further questions, I'd like to reserve the remaining time for rebuttal.
Yeah, that's just fine, Mr. Wilder.
Thank you, sir.
No problem. Okay, Mr. Siegel, good morning.
Good morning, Your Honor. Robert Siegel for the Appellee Airlines. Just to make clear in answer to the panel's questions, in our view, the single issue on appeal is whether the Conrail standard is satisfied. That is a case that was not cited by the unions in their opening brief to this court at all. But that has been the controlling case from the Supreme Court for well over a quarter century. And the issue under Conrail is simply whether the airline's decision to implement the pre-hire employment incentives with the individual pilot candidates is arguably justified by the collective bargaining agreements.
Can you, just in the interest of time, and you both know the case pretty well, can you go to the point that Mr. Wilder was making about the pathway agreement and, Republic makes the payment, but they're clearly doing that in cahoots with Hyannis, et cetera. You know the argument.
Yes. Well, first of all, the Hyannis does make, Republic makes the payment. And it's first of all, our argument that that payment is at least arguably permitted by Section 3.0 of the Republic Collective Bargaining Agreement.
How would that be, given that the Republic Collective Bargaining Agreement only governs its agreements with its pilots? And at the time that, my understanding from the record is that at the time Republic makes these payments to the Hyannis pilots, that they are Hyannis employees.
Well, two answers. First of all, if we ever get to arbitration, what we would argue to the arbitrator is that Republic was bargained for broad discretion in 3.0 to take steps to cure a problem that was identified in collective bargaining, which was a significant pilot shortage, a significant captain shortage at Republic. The parties did not attempt to provide full detail how that discretion would be exercised. And in fact, that's not what normally happens in collective bargaining at all. But the broad discretion was bargained for. In fact, they expanded the language in the collective bargaining agreement to make very clear that Republic had broad discretion to solve the problem.
So that's why you say to go back to the standard, it's arguably justified because that would be our position in arbitration. We would, presumably Hyannis would point to the management rights clause as well, and that the arbitrator is going to have the task of figuring out, is that a reasonable construction or the proper construction?
Absolutely.
And that's the Conrail test. That's your position?
That is our position, and that's what happens.
And that's because there'll be future Republic employees, even though they may not be at the moment?
The entire design, it's a pipeline type process, and Republic cannot hire first officers without the required flight hour experience. The reason they established the pipeline through Hyannis is to enable them to obtain the result that they bargained for. They bargained for a solution to a problem, and they're allowed to first of all have a pre-hire agreement with pilots off the street if they have necessary hours, but they also determined that they would establish a pipeline through Hyannis in order to allow for the accrual of hours and then the promotion, as you say, to become first officers and eventually captains at Republic. But what the legal point here is, the parties didn't bargain every single detail of how this process would work, nor do unions and carriers regularly bargain every single detail about the terms that they establish in their collective bargaining agreement. What they bargained for, and was fairly clearly stated in Section 3.0, was a broad discretion to solve the problem. And the language was made even more broad when they amended the collective bargaining agreement, as the district court recognized. Now, what did they do about the details? Well, this is how airlines and unions always treat a problem like this. They leave the details to the necessities of the moment, and they have a congressionally mandated process for solving whether those details align with the bargaining intent, and that's the system board arbitration process. It's not a creature of contract; it's a mandate of Congress. And that's what we have suggested here. If there is a dispute about how to implement the broad discretion that was negotiated, there is a congressionally mandated process. It's arbitration. Before the arbitrator, you have a full trial. You have evidence. You have witnesses who describe the bargaining history for Section 3.0, and you end up. One party or the other convinces the arbitrator whether or not the steps being taken, such as the pre-hire or agreements or the pathway agreements, were in fact aligned with the permission that was negotiated for in 3.0. But this, if I might just say, this case in a way is a lot easier than Conrail. Conrail, if one reads it, you discover that the collective bargaining agreement wasn't even in the record before the Supreme Court. And the Supreme Court was not relying on the possible analysis of something like 3.0 of the collective bargaining agreement. It took two steps back and simply said that it was fair enough that the carrier could point to some past practice regarding drug testing, and that that past practice might reflect an implied right. And on that basis, the Supreme Court found that it was a minor dispute for an arbitrator to decide, and correctly said maybe the carrier will win or maybe the union will win. Well, here we have bargained for terms that must be given meaning, and they're broadly stated. And so in terms of the pathway agreement that Your Honor asks about, the first answer is that it reflects a pipeline established by Republic to pay, to incentivize pilots to accrue the right number of hours so that they could become Republic first officers and eventually upgrade to captain, which was the whole goal of Section 3.0. There's absolutely nothing that prohibits that, and the Supreme Court in Conrail says it's not an issue of looking for whether it's permitted. Many times the contract will not expressly prohibit or permit, but you have a basic guiding intent of the contract. which was to solve the problem.
And then is the way, given your experience, and Mr. Wilder can chime in on this, is the idea then that with this, what's the terminology, systems arbitration board or?
Yes.
That, okay,
A system, referring to the airline system arbitration.
singular, okay.
Yeah.
Is the idea then that you have industry specialization in the arbitrators, that the arbitrators are quite familiar with the collective bargaining agreements, and they can make informed assessments about what is reasonable just in the interest of efficient resolution, so you don't have strikes and airports paralyzed and things like that?
No, precisely good question. The answer is absolutely yes. In fact, the arbitrators are listed. Usually there's a panel of 5 or 7 arbitrators who are agreed upon by the union and the company and are listed. And then you go through a striking process to pick the arbitrator. But the arbitrators that are used in these situations are not only experts on labor law, they're typically experts on the airline industry. And they've been there, done it. And they understand the dynamic. And in this kind of situation, they will be, if it ever goes to arbitration, asked to assess whether or not the carrier is exercising or taking steps that align with the discretion that was granted to the carrier in Section 3.0 of the one contract and Section 1J of the other contract. That's why it's also more, to be honest with the court, it's just more efficient and more expedited than courtroom litigation. If we didn't litigate that before an arbitrator, we'd have to have a trial before the district judge. And the district judge would be asked to interpret every single term of the collective bargaining agreement that we're in dispute about.
The arbitrators probably have expertise in this area as well.
I know they do, and I think that's why Congress mandated.
So I'm going to ask Mr. Wilder this question, but I'll just get your so why the resistance to arbitration?
I've asked myself that question. If we had frankly, Your Honor, after the district court dismissed the court case, I expected that there would be a request for arbitration, and these issues would have been resolved by now. So I don't know the answer why the union has not done that, but they certainly have the fair opportunity to make these arguments before a qualified arbitrator who is used to hearing questions about bargaining intent, bargaining history, and what the parties intended when they revised Section 3.0 in the manner I've described.
Okay, very well. Thank you, Mr. Siegel. Mr. Wilder, you got some time left.
Thank you, Your Honor. As to that last subject that the court dealt with Mr. Siegel on, it's important to understand that these individual employment agreements do not limit themselves to terms and conditions that are covered by the collective bargaining agreement. They also include state court remedies for the airline against the pilot that include post-employment. The System Board of Adjustment has no jurisdiction over those. The System Board of Adjustment is also not expert in the state law, in this instance of Indiana, concerning non-compete agreements, the ability of an employer to seek liquidated damages from an employee, and when an employee can be required to forfeit compensation that had already been earned and paid. And so this is a somewhat unique case in that you have an airline that has mixed in state law remedies and state law relief into what is otherwise a Railway Labor Act contract. That takes it outside of what is the traditional Railway Labor Act dispute that is submitted to the System Board, and which, at least under the assumption of the Act, the arbitrators have more expertise in. It also means that the unions can't get full relief from the System Board against these agreements because they're not parties to the agreements, and the airline is proceeding in state court separately against these pilots under those state court remedies. That's why we pled an additional ancillary claim, the fourth claim, to the district court. So this is an unusual case in that it is not one in which the unions can gain full relief from the System Board against these agreements that have already been entered and which the carriers are already seeking to enforce. What I'd also point out as to Hyannis is again, Republic concedes those pilots may never become their employees. And so its asserted contract justification first ignores that the Republic agreement on its face plainly excludes anyone other than Republic pilots employed by Republic on the Republic seniority list from its coverage. That can't be disputed. And secondly, it's speculating its ability to use its contract to create an arguable justification at Hyannis is based on the speculative assumption that may never occur. And we would submit that isn't the Conrail standard. The Conrail standard is what are the established practices and meaning at the carrier in question. And then, shortly, I would say, to the extent the district court said that the Republic contract doesn't address its ability to pay benefits to third parties, that simply means the contract can't be interpreted to conclusively resolve the dispute, which is the defining characteristic of a minor dispute according to Conrail. Thank you, Your Honor.
Okay, Mr. Wilder, thanks to you and your colleague, Mr. Siegel, you and your colleagues, we appreciate it very much. We'll take the appeal under advisement. Our fifth argument of the morning is in appeal number 241192, Sean Montgomery versus C.H. Robinson Company. Okay, is it Mr. Patevez? Good morning to you.
Good morning, and may it please the court. Dimitri Patevez for the appellant, Sean Montgomery. We raised two issues in our principal brief. I'm going to rest on the briefs for the second issue and address the first, which is whether the district court erred in granting summary judgment on the agency claim. And at the outset, I want to make one thing clear, and that's we're not arguing that a broker is always liable for agency. It's when a broker steps outside the traditional role of a broker, which is to arrange for transportation, and starts controlling the transportation. And I think here there's a genuine dispute of material fact about whether Robinson was controlling the transportation in this case. In our principal brief, we highlighted 16 different facts that demonstrated Robinson's right to control and showed that it stepped outside the normal role of a brokership.
How do you get around our opinion in Kolchinsky, which is very similar?
So I think Kolchinsky's has some important differences. And one of them is that the carrier in Kolchinsky was responsible for determining the delivery time. So the carrier made the appointments. But here, the carrier was not even allowed to contact the recipient. Robinson was in charge of doing that, and the carrier had no power to change the delivery times. So in effect, Robinson's almost acting like a dispatcher here. It's telling the carrier when it's supposed to get there, and it has control over communications with both the shipper and the recipient. The carrier testified that often the shipper doesn't even know who it is. It doesn't get to talk to the shipper or recipient.
But how does that control how the driver delivered the load, which is what's relevant here?
So I don't think it has to be that narrow that it was controlling whether he turned the steering wheel left or right. It's whether they controlled the transportation. And that's shown, for example, in the Spurl case that we rely on. In that case, the broker didn't have the power to tell the driver when to change lanes or how to drive the car, but it had control.
But there was evidence there that the fines that were imposed and the very tight time frames caused the driver to drive differently. It affected how she performed her work, and we don't have that here.
We don't have testimony saying like that, like Your Honor pointed out, but we do have a very analogous system We don't have specific fines, but the load confirmation that was part of the party's contract, it was an addendum to the contract, said that Robinson could reduce payment or reduce future business opportunities if the carrier failed to comply with any of the terms and conditions. So if the carrier didn't communicate with Robinson or give Robinson the information that it wanted, Robinson could reduce payment. And that's the logical equivalent of a fine. A reduction in payment is the same as making someone pay some money.
Can I ask you a question about this MacroPoint app or software, or whatever it is, that's talked about in the briefing? You know what I'm talking about?
Yes.
Okay. Is there evidence in the record that Robinson used MacroPoint to actually provide instructions and or directives to Montgomery, the driver?
They didn't provide instructions through MacroPoint. MacroPoint was a tracking technology.
It seems like it's a GPS kind of technology or something.
Yes.
Like on the whereabouts of where's the trailer right now.
Yes.
It's not like a texting app or something like that.
No.
Okay. Is that in the record?
The nature of MacroPoint?
Yeah.
Yes, it's discussed in the depositions. I believe Mark Musgrave talked about it.
Okay.
So this was something that the driver had on his cell phone, and it allowed Robinson to know exactly where he was.
Yeah, so that's it. You emphasize that a bit in your brief as being indicative of one factor indicative of control. That's hard for me to see that, because to my mind, all that's doing is it's letting the freight broker know the whereabouts of the trailer, probably to assess whether a delivery deadline is going to be met, or to keep a customer informed or something.
Right, but the question is, did Robinson require the driver to do that? And here, there's evidence that Robinson did require the carrier to do that. The load confirmation sheet, which again was part of the party's contract.
But that's what in your view, that's what the case. So Robinson also said you need a 48-foot trailer because this is a pretty good sized load. Those are indicia of control, as opposed to if you show up with a 24-foot trailer, this is going to be a major problem.
Yes, those are indicia of control. Under Illinois law, the provision of equipment is a factor to be considered an agency. And in fact, in this court's Kolchinsky decision, when it was talking about Spurl, which affirmed a jury verdict for the plaintiff, it described Spurl as upholding a finding based in part because the broker told the carrier what kind of equipment to use. And that's what.
Oh, but it was a lot more than that. It wasn't decided based on that particular fact.
I agree, Your Honor. And every agency case is based on all of the circumstances. There's no one single fact that controls. And we're not arguing here that any of these particular facts is what decides the case. It's when you take all of them together, there's a genuine dispute of material fact for the jury to decide the issue of agency. Another factor that was important in the Spurl case, and that this court highlighted in Kolchinsky, was that the driver in that case was required to monitor the temperature of the trailer, keep it at a certain temperature. And although that wasn't a requirement in this particular load, we do have load confirmations for prior loads with this same carrier where the driver was required to do that. And the district court didn't even consider them. In a footnote in its order, it dismissed those prior load confirmations as irrelevant. But those load confirmations were not irrelevant. Under Illinois law, you consider all of the circumstances, and that includes the past behavior, because that shows Robinson's right to control. Unless this court has any other questions, I'd like to reserve my time for rebuttal.
Okay, very well. Mr. Prasadi.
Thank you, Your Honors, and good morning. May it please the Court. Paul Prasadi for the C.H. Robinson Appellees. Your Honors, an inference is not reasonable if it is directly contradicted by direct evidence at the summary judgment stage. That comes from this Court's opinions in Rexa and State Farm, which we cite on page 20 of our brief in the standard review section. And that is the problem with the evidence that's presented. It relies on inferences that Robinson had the right to control some manner of delivery. But the direct evidence on that point, to Your Honor's questions during counsel's argument, is that Robinson did not have the right to control the manner in which this load was delivered. I went back and listened to the Kolchinsky oral arguments. Judge St. Eve, you asked how they get around Kolchinsky. I don't think they can. The two questions that the court asked in Kolchinsky was, did the broker in that case control the routes taken or the hours of service, the hours driven? The answer in Kolchinsky was no, and the answer here is no. And in fact, Robinson, there's many other things that Robinson did not control or even have the right to control about the carrier's business or how the driver drove. I think counsel mentioned that that a traditional carrier-broker relationship does not give rise to an agency relationship. That's correct. In fact, Kolchinsky said that courts applying Illinois law routinely or consistently find that where a company hires an independent driver to deliver a load from A to B, dictates the location and the time frame, the delivery times, but does not retain the right to control, that is not an agency relationship. And that's where the criticism in the reply of our brief when we describe that this broker relationship between Robinson and Kareev and its driver was just a typical carrier-broker relationship in which Robinson did not retain the right to control the load. That is relevant because nothing about the facts of this case and the reasonable inferences that you can draw from those, that the district court did draw from those, show that Robinson had the right to control the manner of delivery. Judge Scudder, you asked about MacroPoint. First, it did not require two-way communication, or did not allow, two-way communication. That's on document 138-4 at the deposition page 215, lines 6 through 9. Undisputed testimony, it did not allow two-way communication. And I encourage the court to look at document 138-4 at page 79, which is the actual data that that MacroPoint provides. It is exactly as the court described it, or as Judge Scudder, you described it. It's pinging where the driver is. It's a purely location. And so it didn't allow or give even Robinson the right to go into that system and contact the driver. Hey, where are you? And in fact, that document showing the pings, there's two notations. The district court noted that Robinson did not interact with MacroPoint during the load. There's two notations from a Robinson representative, Mr. Musgrave. There's one initially when the tracking begins, and the second one doesn't come till 8:15 a.m. on December 7th. That is about 8 or 7 hours after the accident occurred. And the timeline is important because if the accident occurred at midnight and Robinson doesn't make a notation on MacroPoint till about 8 or 7 in the morning, it's not using MacroPoint to go in and say, hey, why are you stopped at this location in Illinois for 6 hours or 4 hours? And the undisputed testimony is that the driver, after the accident, waited to call Kareev, his boss, I think, till the next morning. So that's when, and then his boss, Mr. Lopez, contacted Robinson. Judge Scudder, you asked about the 48-foot trailer. I agree. The point of the 48-foot trailer, first, there's undisputed testimony that those were customer-specified requirements, meaning C.H. Robinson's customer is telling the carrier, or telling Robinson, hey, we need this. We can't fit a load in a pup trailer, in a half-size trailer. We need a 48-foot trailer.
I mean, it seems to me very hard for Robinson, in the way in which the briefs describe this being done, where you put, it's basically like it's a portal or something, or a bidding system, where you put these prospective jobs out there that somebody that's going to accept a job, a carrier, is going to need to know what's the job entail.
Well, that's exactly right.
Do I need an 18-wheeler? Do I need the equivalent of a UPS truck? Is it 4 hours away or 24 hours away? I mean, you need some sense of that.
Well, that's exactly right, Your Honor. And actually, that brings up a good point. The load board in this case was a load board where Robinson put out loads.
Is that what it's called? That portal is called load board?
Called a load board, right? I think that's how the testimony referred to it. And that's what really distinguishes this case among many other things from the main case that they rely on, which is Spurl. In Spurl, the carrier's driver, went out and contacted Robinson directly to obtain a load. It didn't go on a passive load board. It didn't have its carrier go out and contact. The driver went out and got the load. Then, after the load was completed, Robinson directly deposited money into the driver's bank account. The goods that were being shipped in Spurl were Robinson's own goods. It wasn't a third party like we have in this case. There were two third parties here, a shipper and a receiver. Robinson was the one in the middle brokering the load. Didn't own the flower pots being shipped. The shipping location was not Robinson's facility like it was in Spurl. And I think in the reply brief, and in fact, that's on top of Judge St. Eve pointed out, the Spurl testimony, that the requirements that Robinson imposed on the load in Spurl, the delivery times, The driver testified that she could not complete the route without violating federal regulations on hours of service. And we have no similar testimony that the macro point application or any other quote-unquote requirement that was put on this load affected how the driver drove the load or how Carib operated. And another point, important note in Spurl, Your Honors, that involved C.H. Robinson, no doubt. That was that accident from 2004, so 13 years before the accident. The Riley case, which also involved Robinson, was from 2000. The accident was 2014, so 3 years before the accident in this case. And Robinson and Spurl made a similar argument that Mr. Montgomery makes here, that, hey, look, these previous 2 other reported cases, Robinson was not found to have been the agent. And therefore, that must support that our relationship with this carrier and this driver also is not an agency relationship. And the court rejected that, saying there are important facts in Spurl that were simply not present in the case here. And that's what we have here. And in fact, in noting that, the court noted that Robinson did not own the goods in those 2 previous cases, did not have the facility that was being transported to, was not a Robinson facility. And that's exactly what we have here. Just because Robinson was found to have an agency relationship with other carriers or drivers in 2 previous cases doesn't support the idea that they have a carrier or agency relationship with this carrier and this driver here. Your Honors, unless the court has any more questions, I appreciate the court's time, and I'd ask that the judgment of the district court be affirmed.
Okay, very well, Mr. Brusati.
Thank you.
Mr. Tevez, you have some more time.
Thank you. I'd like to briefly address some more facts that I think show Robinson's right to control. And one thing you heard opposing counsel talk about was hours of service. And here, Robinson had the ability to call the carrier and ask about the driver's hours of service. That was something that was testified to. That's not something that a broker, someone who's arranging transportation, would necessarily need to do. But here, Robinson wants to control the transportation from point A to point B, so it's asking about hours of service. Another thing Robinson did was it had a right to know about the extent and location of all of the carrier's trucks and drivers. So again, that's not something that pertains to an individual transportation. That's showing Robinson's control over the carrier in general. Also, we have Robinson tracking performance and assigning ratings to the carrier. So this is kind of similar to the fine system. It's incentivizing the driver to behave a certain way because the carrier is receiving a rating based on their performance, whether they're on time or whether they don't do something correctly. So this wasn't a case where Robinson was just dictating the arrival time and just dictating the container that needed to be used. You had all kinds of rights to control. Another one was Robinson could basically tell the carrier to assign a different driver. How is that a traditional role of a broker, to tell a carrier that it can't use that driver for a particular load? That's demonstrating that Robinson has the right to control the carrier. And that's also a fact that wasn't present in Kolchinsky. We didn't have, there was no evidence, at least from the opinion, that the carrier, that the broker could tell the carrier to use a different driver, that the broker could look at the hours of service, or that the broker assigned performance ratings. So all of those facts are missing. And again, no case is going to be alike. The Illinois courts have said you have to consider all of the circumstances. It's fact-by-fact analysis, and the important factors can change depending on the context. And here, we're asking this court to reverse because there are, at the very least, genuine disputes of material fact for the jury on the question of agency. Thank you.
Mr. Tevez, thanks to you. Mr. Brusati, again, thanks to you. We'll take the appeal under advisement. Our final argument of the morning is in appeal number 24-1329, Consolidated Coal Company versus the Federal Office of Workers' Compensation. Mr. Mattingly, good morning.
Good morning, and may it please the court. I'm William Mattingly, and I have the pleasure of going last on a 6-case docket, which is as excited as you can be when you check in the morning. This is a black lung benefits case that arises from the agency. Unlike this court, where you get dissenting opinions, the Benefits Review Board, the Intermediate Appellate Review Board, doesn't frequently have dissenting opinions. So that sets this case apart in one way. It has one major medical legal issue that we're asking you to resolve, and that is whether or not chronic and acute comes into play when you're trying to determine if there's total disability. Why does that matter in this case? Given the years of employment, this gentleman's widow could avail herself of the 15-year presumption if she proves that he was totally disabled prior to his death. There's a split of medical opinion on that question. The administrative law judge looked at it and said, based on the hospitalization records, I'm convinced Dr. Shavda finds, and I infer that he would find, since this gentleman was on a ventilator, he couldn't go back to work, hence he was totally disabled. The physicians we relied on said, you can't look at that hospitalization. It's all due to an acute pulmonary impairment and disease. You have to go back and figure out if there was a pre-existing disabling impairment from pneumoconiosis. We don't think there was. So, the director has very strongly come out in their brief and said, we are wrong, Judge Boggs from the board is wrong. You don't even consider acute or chronic when you look at pulmonary impairment. They point to the 15-year presumption in the statute, and sure enough, it just says pulmonary impairment, pulmonary respiratory impairment in section 30 U.S.C. 921. It doesn't say acute or chronic. But go back up in the statute in that same provision. It directs the secretary to set the standards, to promulgate and define total disability. And when the director did that at 20 CFR 718-204, I think they very clearly said, we're only going to consider chronic pulmonary impairments. I've been doing this work since I got out of law school. For almost 40 years, when I started with the Department of Labor and then migrated to defend coal companies, I've always looked at that section as requiring chronic pulmonary impairment. Not only is there a reference to that early on in the general provision, where the director specifies if you've got non-pulmonary conditions that are causing a pulmonary impairment, they have to be a chronic pulmonary impairment.
What language are you looking at?
I'm looking at the language in 718-204A, the general provision.
Okay.
And granted, the director's right. They didn't say acute. They just said chronic there, and they didn't say anything about if there is a primary pulmonary disease. But you can't look at the regulation without seeing how the director applies it. And when they go down, there are various different studies that administrative law judges typically look at to assess pulmonary impairment. Breathing tests, pulmonary function studies, arterial blood gas studies. And the director very specifically explained in the regulations and the appendices to the regulations that you can't rely on a pulmonary functions test that's done too soon after an acute illness. You can't rely on arterial blood gas studies that are done during a hospitalization. The question is why? The answer why is because it reflects acute pulmonary impairment, and that's what we're not interested in these disability cases. And I think that's also consistent with the definition of pneumoconiosis. Whereas Congress defined pneumoconiosis, and the director has parroted that in the regulations, it means a chronic dust disease of the lung and its sequelae, including respiratory and pulmonary impairments arising out of coal mine employment. What the director's forgotten is the definition of sequelae, a condition that is a consequence of the disease. And when you read that together with the way the statute starts off with chronic, I don't think it infers, I think it defines the disease that Congress is interested in compensating here as a chronic disease that causes chronic pulmonary or respiratory impairments.
Yeah, can you help me on that, Mr. Medley? Because that seems to me, and I'll ask your adversaries for the same point. It seems to me to be a little bit circular because you're looking for, as you say, not an acute condition at the time of death, but rather whether there was a chronic condition, correct?
Correct.
But you're looking at whether there was a chronic condition to figure out whether the minor had pneumoconiosis, which itself is defined as a chronic dust disease. So it seems like just help me unpack that. It seems circular.
It is. But what you're really looking for is there a pulmonary impairment? Because they're entitled to this 15-year presumption.
That is totally disabling?
Right. So we're not even getting to the pneumoconiosis question. But my argument is the way the director defined pulmonary impairment in 718-204, they only took into account chronic pulmonary impairments, not acute ones. And by explaining you can't rely on studies that are affected by acute diseases, that is consistent with the way Congress defined pneumoconiosis as being a chronic disease with its sequelae of
But
chronic
it doesn't preclude
impairments.
consideration of doctors' opinions that have relied on those tests.
Correct, but the question that the administrative law judge has to answer is, did the doctor separate chronic from acute? And that's where Judge Boggs agreed with our position below before the board, that this administrative law judge didn't make that differentiation when he considered the medical opinions, and that makes his considerations invalid.
If you are correct that you have to prove a chronic condition in order for the 15-year presumption to be invoked, what's the difference with the 10-year?
10-year presumption deals with the existence of pneumoconiosis. So in black lung claims, you've got 4 elements.
Which is a chronic disease.
Yes. So it would be similar, but you can have pneumoconiosis, a dust disease that arises out of other things than coal dust exposure. You can have it arise out of rock exposure when people are doing sandblasting. So that would not qualify as pneumoconiosis. It would be presumed to be pneumoconiosis if someone worked more than 10 years. If they worked less than 10 years, they'd have to show that it was.
Mr. Manley, are you, we get some Black Lung Act litigation, but not nearly as much as the Fourth and Sixth Circuits. Have either of those courts addressed this legal point that you're making?
They have not.
And yeah, that seems odd to me.
It just has not come up in the cases.
And why is that?
Because most administrative law judges apply the regulations as I am suggesting, and they look for chronic impairment rather than acute impairment.
Okay.
I'd like to save the rest of my time for rebuttal.
Yeah, you're welcome to. Okay. Mr. Vowles, good morning.
Good morning. May it please the court, Austin Vowles. I'm here arguing for Bernadette Staten, who is Mr. Staten's widow in this claim. The coal company really makes 2 primary arguments here. One is that total disability must be proven chronic, and the other is that the board erred by adding language to the ALJ's reasoning. I'm going to address that second one first because it's really easy to get through. The board's reasoning is practically irrelevant at this point because this court does essentially the same review. What the court does is they allow the ALJ to decide the facts like a jury would, and then they review the questions of the law de novo. So while the coal company has spent a lot of its brief arguing that this court reweigh the evidence and decide these facts, the precedent is clear, the standard of review is clear that this court should not do that. Rather, it should afford the ALJ the discretion as the fact finder. So that covers the first issue. Now back to the
Hold on, let me pause you on that. What if any role in our review does the Benefits Review Board opinion have?
I think none at all, to be honest with you. I don't think that, I mean, you could make a different decision than them by reviewing the ALJ's decision and coming to a different outcome. But if there's nothing really for you to review that the board decided. They don't decide the issues of fact, they just decide the issues of law. You all do the same thing. So that's my take on that. Is it okay to go back to the...
Yeah, go right ahead.
Okay, go back to the first point. So whether total disability must be proven chronic, the answer to that inquiry is easy to find because total disability is defined in the regulations, as Mr. Mattingly explained. The U.S. Code actually defers to the regulations on that issue, but he is actually pointing it largely at the wrong regulation. It's 20 CFR 718-204B, Section B, not Section A. That's where you get into the specifics here. And the regulation explains that a minor is considered totally disabled if the minor has a pulmonary respiratory impairment which, standing alone, prevents the minor from performing his or her usual coal mine work and from engaging in gainful employment in the immediate area of his or her residence requiring the skills or ability comparable to those in any employment in a mine or mines in which he or she previously engaged with some regularity over a substantial period of time. Lacking in that definition of total disability is the word chronic. Page 34 of my brief, I've got a whole section dispelling the coal company's contrary claim. The coal company, they've artfully tried to work the word chronic into the total disability definition with its legal argument, but if you read the regulation, it's just not there. Even more, under 30 U.S.C. 921C4, the presumption that a minor's death or total disability is due to pneumoconiosis gets invoked by a showing of total disability and that a minor has more than 15 years of coal mine employment. Mr. Staten had 28 years of coal mine employment. But as the court was alluding to earlier, what's key in that analysis, in that framework, is that pneumoconiosis and causation both get presumed. So one should not have to prove a chronic condition to have a chronic condition presumed by a statutory presumption. It is very circular reasoning that the coal company has engaged in there. Regardless, though, of whether the coal company's argument on chronicity is accepted or not, it shouldn't be, but regardless, it does not matter because in this case, the ALJ found Mr. Staten's condition to be chronic. The administrative law judge accepted Dr. Chavda's opinion. This is on page 15 through 17 of the joint appendix. Dr. Chavda found total disability due to a chronic condition. The ALJ found Dr. Chavda's opinion well documented, well supported, and accorded it probative weight. So it doesn't really matter in this case. The issue, if the law were, as the coal company suggests, to be a harmless error, Mr. Staten being found totally disabled isn't really controversial. He had objective tests showing respiratory disability back to at least 2013. He died in 2017. He had a qualifying pulmonary function test under the federal regulations that would make him be found totally disabled. He had diffusion capacity that was low, that according to the AMA guides would show that he had significant impairment. He had an oxygen walk test where he only walked for 2 minutes. He walked for 2 minutes, and his oxygen desaturated to 87% after walking for 2 minutes. So just a few other notes I want to hit. The presumption that a minor is totally disabled due to pneumoconiosis that we've been discussing, it existed in a version of the act that was in play in the 1970s, but Congress actually deleted it in 1981. And it was missing from the law, that presumption. You didn't get that presumption. You had to prove everything. From 1981 until 2010. In 2010, Senator Byrd put it into the Affordable Care Act, and it was re-implemented in 2010 with the Affordable Care Act. So it's back in place. So if you're reading the president and you're looking at these different decisions, the framework's different from 1981 to 2010 than it is currently and than it was in the 1970s. Last but not least, just explain, the quote from the Sixth Circuit, and they're looking at the Black Lung Benefits Act. It's that it's remedial legislation that should be liberally construed to include the largest number of minors within its entitlement provisions. The difficulties faced by minors with severely limited resources in proving causation are considerable. Congress enacted and subsequently amended the act in large part to permit benefits to be awarded to minors whose entitlement under state workers' compensation program were precluded by burdensome causation requirements. And we believe that's what the coal company here is advocating for, these burdensome causation requirements that really that's the whole purpose of the act is to avoid that here. So with that being said, I appreciate your time today, and I would ask you to decide this case in Mrs. Staten's favor. Thank you.
Yep, you're welcome. Very well. Mr. Goldberg, good morning.
Morning, Your Honors. My name is Jeff Goldberg. I'm representing the Director, Office of Workers' Compensation Programs. And really question is whether the claimant bears the burden of proving that a minor's pulmonary disability is chronic in order to invoke the 15-year presumption of entitlement. And really this issue begins and ends with the plain language of the Act and implementing regulations. Did want to point one thing out first. A lot of this is going to sound redundant after the two arguments you've just heard. Section 718.204A that says causes a chronic respiratory or pulmonary impairment, the last phrase of that sentence says is or was totally disabled due to pneumoconiosis. That is the import of the word chronic, because there is the question of what causes the disability. Now, the 15-year presumption is invoking the 15-year presumption is based on two things. The minor has to, or the claimant has to prove at least 15 years of coal mine employment and a totally disabling respiratory impairment. The Act does not define total disability. It assigned that responsibility to the Department of Labor, and we defined it as a pulmonary or respiratory impairment which, standing alone, prevents or prevented the minor from performing his or her usual coal mine work. There is no mention of chronicity.
No mention of what?
Chronic condition, a chronicity. It's an awkward word. But to rebut the presumption, where the burden shifts in this case to consolidation or to consol coal, they can either establish that by proving the absence of pneumoconiosis or that the disease played no role in causing the minor's death. The Act does, unlike total disability, define pneumoconiosis, and it defines it as a chronic condition. It is therefore a consol's burden to prove that the disease is not chronic. If they can prove that the disease that caused the minor's death was not chronic, they have by definition proved that the minor did not have pneumoconiosis or that the pneumoconiosis didn't play a role in the minor's death.
Mr. Kohlberg,
Yes.
since you are very familiar with this area of the law, Mr. Mattingly suggested that the ALJs generally apply his approach to the 15-year presumption and require proof of chronic. Do you agree with that representation?
No, I don't think I have ever seen an ALJ say, this minor is disabled, but it's disabled to an acute rather than a chronic impairment. Because what the judges do is they base their opinion on the medical opinions. And a doctor will say this minor is disabled or is not disabled, and it's due to pneumoconiosis or it's not due to pneumoconiosis. If it's not due to pneumoconiosis, if it is due to pneumoconiosis, he has a chronic disease causing the disability. If it's not due to pneumoconiosis, the minor doesn't get benefits. It really is just that simple.
Has there been any other circuit address this question to your knowledge?
No, here I do agree with Mr. Mattingly. I haven't seen one. If there are no other questions, thank you very much for your time.
Mr. Goldberg, thanks to you.
It's always nice to have the director agree with me on something. So we'll count that at least as a partial victory. Let me pinpoint the argument. The director's position doesn't make sense. Because here Dr. Shavda said I can't use the blood gases from the hospitalization because they were due to an acute illness. The administrative law judge agreed and said I can't use those tests to establish disability because they're due to an acute illness. You can't have it both ways. The director's defined under section 718.204C medical criteria, and that trumps the B provision that Mr. Valves was talking about. But that medical criteria must be done when there is not an acute condition. It is inferred, it's not well written, it's inferred that only chronic pulmonary impairments are what you use to establish total disability. And that's the crux of the case. If you agree with the director that you don't need to do anything, then their regulation has to fail. It needs to be thrown out because they've defined total disability and excluded acute conditions in the medical criteria for total disability. So it makes no sense. Thank you.
Okay, Mr. Mattingly, thanks to you. We appreciate the argument on both sides. We'll take the appeal under advisement, and that will conclude today's arguments.